Hey everybody, it's Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about 5 things that a revocable living trust can do that a will cannot. Before I get to that though, I want to remind you, if you have questions about this or anything else related to estate planning or probate, you can talk with us over the phone or in person for free by going to estatemeeting.com. Okay? Now, 5 things a revocable living trust can do that a will cannot do. A lot of people ask this question. They want to know, like, what's the difference between a will and a trust? How come I can't just do a will? And the answer is, by the way, you can do a will. You can do nothing. The point of this video, the point of all my videos, the point of the conversations that I have with all of my clients and potential clients is to just make sure that you are making an informed decision. Okay, there is no right or wrong answer when it comes to these things, except for the answer that is right for you and your family. Okay, I always say, look, it's not my money, it's not my family. I don't care what you do with it. I just don't want you to do something that has a consequence or has an effect that is unintended for you and your family. Okay, so let's dive into these things, and they're pretty straightforward. So number one, first thing that a revocable living trust can do that a will cannot is avoid probate. All right, I've talked about this before, but basically you have to think of a trust as a box. Okay, you create this box. It's right here. You are in charge of the box. You can put anything you want into the box. You can take anything that you want out of the box, but this box remains even after you die. So the idea is you move everything into the box, and then when you die, you don't need probate, because probate is the process of transferring your assets from yourself to someone else. Okay, this process is not needed if you have a trust, because the trust technically continues to own the property even after you die. So there's no need to change the ownership. Okay, hopefully that makes sense. If you have a will and you say, I'm giving everything to, Joe Smith, then you have to go through probate to transfer everything that I own to Joe Smith. Okay, that's what probate essentially does. But if you have a trust, I would put everything in the trust, and then I would say, hey, the trust, give everything to Joe Smith. Then when I die, the trust still holds everything. The trust just gives everything to Joe Smith. There's no probate. That's number one. Number two, the second thing that you can do is you can create some divorce protection. Okay, you can also, or slash bankruptcy, slash liability. Basically, you can create some asset protection for your beneficiaries that they would not have with a will. Give you a perfect example. Let's say I'm in business and my business fails. Okay, I want to make a widget. I have a widget factory, and the widget factory fails. I declare bankruptcy, and I've got some personal debts that I get rid of in this bankruptcy. If somebody dies and then gives me something via a will, that stuff is going to go into my account and it's going to go directly to my creditors. Okay, it's going to go right to them, so I'm not going to get to feel the advantages of that. If I have a trust, if the things are given me via a trust, then that money would go into the trust, and then the trustee could utilize that money for my benefit without actually giving me the money directly. For example, if I needed a car, they would buy a car in the name of the trust, and I could use it. Instead of giving me the money, it goes to the creditor. It's actually available for use by the people that you want to have used it, and not just going to some creditors that you didn't want your assets to go to. Okay, hopefully that makes sense. Same with divorce. Trust property remains separate property, so it actually remains not even the person's property. So if you are getting divorced, assets in a trust, most of the time, okay, 99% of the time, are not going to count when you're talking about dividing up assets in a divorce. Okay, so that's number 2. Number 3, I made a list. This is what most people think of when they think of a trust, and that is you can extend the distribution and the management and the oversight of assets over a long period of time. With a will, you have outright distribution. Joe Smith gets everything. As soon as it's ready, it just goes to him. Okay, with the trust, you can say Joe Smith can utilize these assets for health, support, education, and maintenance at the discretion of the trustee, which means he's got to ask the trustee before those assets can be distributed. You can also then say when he turns 25, he can have a third. When he turns 35, he can have a third. And when he turns 40, he can have the rest. Something like that. And then the trust will hold those assets and extend them out over that period of time. Okay? Number 4. Maintain family property. I've done this several times. I've seen this done several times. Let's say you have like a vacation house. You have something out on Bainbridge Island, and all the family uses it for vacations and fun times, and you want that house to remain in the family for a long time, but you want to prevent squabbling. You want to prevent arguments over whether the house should be owned or not. You can put the house into a trust, and you can direct that the trustee maintain the house and have it available for family use forever, basically for as long as you want. That way, you have extended the life of this property for your family. You have eliminated any concerns and squabbling, and everybody gets to have a good time. Okay? Last but not least, number 5 is create generational wealth. Some people do this, and again, this is your prerogative. I'm not here to tell you what to do, but if you have significant assets or you have not significant assets, you can do this either way. Sometimes people will create a trust and they will have no outright distributions. The distributions for the beneficiaries are only for support, health, maintenance, education. In that case, all of the assets might not be used. If that's the case, then the assets that are left over can be used for the grandkids and the great-grandkids and the great-great-grandkids. Often what will happen is a trustee will take out life insurance policies on the current beneficiaries, so that when the current beneficiaries die, those life insurance proceeds funnel back into the trust and then fund the trust for the next subsequent generation. This is what the Rockefellers do. This is what like the Kennedys do. They use life insurance to continue to bolster up the value of their trust for multiple generations down the road. Okay, so there you have it. 5 ways that a revocable living trust is different from a will. Let's go through them again real quick. We have number 1, avoid probate. Number 2, we have divorce/bankruptcy/creditor protection. Number 3, by the way, this is for down the line beneficiaries, not for you. Okay. Number 3, extend distribution for beneficiaries. Number 4 is maintain a family property. And number 5 is generational wealth. All right. Hopefully that made sense to you. Hopefully maybe spark some ideas for the things that you might want to do for your family. If it did or if it didn't, that's great. If you like this video, please hit the like button. If you know someone needs to hear this, please share it with them. If you have a question or comment, please leave it. I am Christopher Small. I'm the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. If you have questions or comments or need help, you can go to estatemeeting.com. You can set up a time to talk with us over the phone or in person for free. estatemeeting.com. Okay, that is it for today. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again tomorrow.